walk us through this bill. We are live, we are back. And we are on to page 650. This is right,
Yes.
650, enaculating for educational technology products. So this is coming to us from Housing and Economic Development or Ed?
Senate.
Senate Ed, okay. And walk us through.
Good afternoon, Rick Sagal with the Office of Legislative Counsel. So H650 is an educational technology bill. Page 1 of the bill is a technical correction to the underlying chapter of student protection of personal information, student privacy. The correction is the current language has a chapter for enforcement, while it should just be that subchapter. That appeared to be a mistake made several years ago in that section. So nothing super substantive here, just correcting a technical issue there.
You've been doing a lot of large scrutiny corrections. Yesterday.
Of my, yeah.
No, of everybody.
Oh.
I think we're rushing things. Yesterday it was a comma. But it changed the meaning.
Now this was years ago, Madam Chair, in my defense. I can't speak to my colleagues. So on the bottom of page 1 begins the substantive portion. Add in a new subchapter in this chapter 62, Title 9 of Educational Technology, which sets forth some registration requirements. It defines what an ed tech product is. It is, hold on, do I have the, this is the has passed my house version. Let me pull up the Senate version. Okay, same, first page is the same. So we have the same EdTech subchapter registration defining what an EdTech product is. It's any software, application, or platform that collects, processes, or transmits student data, and that is used for teaching and learning purposes at the School of Vermont. A filing is any type of filing with the Secretary of State, includes initial registration amendments, a report, those kinds of things. A provider of an educational technology product is a person that provides an EdTech product that is in use at the school. And the school includes public schools and independent schools that are approved under 16 VSA 166. School district also has the same meaning as 16 VSA alumni. So a person that registers as a provider of an EdTech product, when they make that filing, so this would be if they register with the state as an LLC, if they file reports as part of the reporting requirements, would also provide the following: the name and email address of the person, website address, a link to their most recent privacy policy and terms and conditions of each product in use in any school, the name of each school in which the provider operates pursuant to a paid contract, the name and a brief description of each product, also indicating which products are offered at no cost to schools, which products are known by the provider to be in use in any school, and finally an attestation that each product meets current state law, which includes a student privacy law, the Vermont Age Appropriate Design Code, Common Sense Kids Code, and then all other relevant federal and state privacy laws.
That's really quick, Madam Chair. So up above it says initial filing amendment, whatever. If the business isn't registered in the state of Vermont, like their headquarters isn't here, would we ever know? Or is this a separate thing where if you do provide this product, you do have to register in the states?
The idea is to capture business that has customers in Vermont, and you should be at the very least establishing a foreign business doing business in Vermont. So if you're a California Texas Corporation LLC, a business who does business in Vermont, either online or in person, should be registered with the Secretary of State as a foreign entity.
So like Google or
Yes.
whatever, they register.
They should not.
This is doing the insurance type foreign entity needs outside of Vermont.
Right. It's a pass through since, just so the state has a record of who you are. Do you have a registered agent in the state? So if you get sued, if you sue Meta,
where to
Google,
The paper.
right? That's what you should be doing. The House version, or at least the introduced version, did have some enforcement with this. There were some registration fees with this. They were taken out by the Senate. So it's kind of a honor system to some extent. So if an ed tech provider doesn't register, there wouldn't be any penalty besides the underlying penalty of doing business without registering.
And is that underlying fee why it's here?
Yeah, so as introduced, there was, well, and I think Ezra has some information,
Okay,
but yes, as introduced, there was not just a fee, but also a penalty if you did not register.
okay,
Those are gone.
all right.
When you talk about a product, is that a product that has to be sold directly to the school? It could be sold through a third party, such as a distributor of products.
So it's any product that, as the definition says, that collects, processes, or transmits student data. So it would be a provider of that product, and the provider means the person that provides it, which is.
So it could be a distributor rather than the manufacturer of the products. And then the question is, does the distributor have any control of what's in the product?
This was briefly discussed in the committee, but they were eventually happy with the way it was worded.
So would it typically a distributor, where the distributor is, eBay, or the distributor is some other Joe's educational products company who purchases products or gets products from another entity, and then that entity is the product that is sold.
So my read of it is the example eBay would not be. Even so, they're kind of a middleman to some extent, or they're just distributing the product. It would be
More like
limited
the
to.
distributors that were just here.
So Google, for example, they have Google Classroom, right?
Right.
It's a large entity, but they also provide directly this product that serves teaching or learning purposes.
Mhm.
So I can't say that it's not always going to be this distributor, but I think it's meant to target the entity that is actually making that product
And that's my point is whether or not you could get to the entity making the product if the product is being sold and provided to you through a distributor. You're buying a product and it's prepackaged, it's got all the software and so on necessary to operate it and the instruction manuals and so on, and you're buying it from as a commodity from some other product. You wouldn't expect eBay to go in and repair that product and change it to meet your specifications. They're selling it as a commodity. And I'm just wondering how this legislation deals with that kind of situation, if at all.
So I think that there could be a question, but if you want to exclude distributors or if you want to.
Let's just keep walking through
Okay.
them. It may become wrong.
So finishing up with that section, moving on to section 2, a totally separate section. This is a 2-year pause on chatbots in schools. A is the intent section. I won't read that. You're welcome to read it. Subsection B is the substantive portion. So subject to the exception in subsection C, no school shall allow students to use a chatbot for teaching and learning purposes until June 30th, 2028. The exceptions are that a school principal or head of school shall have the authority to grant an exception, provided the chatbot is educationally warranted, which is not defined. So it would be up to the principal or head of school to make that determination. Subdivision 2 is a different type of exception where a student that has a 504 plan or some kind of accessibility for a plan with the school that requires use of chatbots, they would be allowed to use that chatbot with or without the principal's approval. There are definitions. Chatbot is any AI, algorithmic, or automated system that generates information via text, audio, image, or video in a manner that simulates interpersonal interactions or conversation. Pretty broad definition. And school is a public school or independent school. For number 16 DSA 166. And we shall provide notice of this provision and if necessary, provide support to a school implementing its provisions on or before August 1 of this year.
What is this? On paragraph 2, line 14, page 4. I understand that it's for part of the IEP or 5-4 plan.
Mhm.
Provided, however, that if such use is required to meet an international student's special education needs or as part of a disability, and an international student does not have, what is this in here?
This language is from the cell phone bill that the legislature passed last year.
So this might be a translation service.
So there are apparently some international student, that doesn't have, for some reason, maybe they're not eligible for those other plans. I don't know, the 504 plan.
But this is just saying about international students' special education needs or disability accommodation. What about just an international student? And wait, an international student, does that mean like an exchange student, or does that mean a student who doesn't speak English, or what does international student?
EL student or
Yeah, I mean,
New American or what? Yeah, that's weird.
I don't, yeah, it's not a term that we usually use. It's in college, it's used,
Right.
international students.
I thought international student typically means someone who is from another country here, usually temporarily.
Exactly, like an exchange student
Yeah,
or something.
exactly.
This seems like strange wording. And then is it only for if they have special education needs, not if they have just general translation or?
Our independent schools do have international students. I bet that's what where that's coming from.
Oh,
So maybe a question for Brett St. James, as this came word for word from the cell phone school bill, which was recommended to be placed into this to capture anything that subdivision 1 does not capture. For the first
weird.
3 lines of 2.
What are we? I guess I'm trying to figure out what problem we're trying to solve
Would the chatbot cost general or
with
with
the whole bill. With and do I get to ask that too? I don't know if it's fair to ask you.
Senator Robinson, I would love to speak on this.
No, been hearing that this week.
She's the presenter of the bill, but I think what you might be trying to solve,
Yes.
if I understand this.
So,
There are some real concerning things about AI chatbots and interacting with kids and how it's very unregulated in what they do, what they tell kids. So I think the intent is positive. I just don't know if this approach is necessarily the right tack. And I have a lot of confidence in how our schools are run to be less kind of restrictive.
Yeah. I agree. It sounds like
local control, you mean?
That's right, buddy.
we're outlining a lot of things. Okay, but Sesame Street is still all right. Okay. Let's keep going.
The last section is the working group. That would be a legislative working group. Look at
I'm gonna nominate
To
Senator Matthew for this one.
I think it'd be education vendors.
well, let's see who the membership. So it's the purpose is to study ed tech products in the state and providing a recommendation on how it can certify such ed tech products. Membership is 3 current members of the House, not all from the same party, 1 by the Speaker, and 3 members of the Senate, not from the same party.
Legislators definitely have this kind of expertise.
We do.
Yeah,
Just
we
like-
should definitely be deciding.
School redistricting.
It is starting.
Okay, that's boilerplate. Let's keep going.
Uh,
It's Friday afternoon, folks.
So
For anyone that's listening.
the working group consults with AOE, the Vermont Superintendents Association, the Vermont Independent Schools Association. Shall 1, create a list of ed products in use across schools. In consultation with the Secretary of State, review all ed tech product registrations pursuant to this bill as creating that registration process. Interview stakeholders, including teachers and children's privacy advocates, to determine the benefits and harms of using ed tech products in the classroom, including chatbots. 4, recommend whether parents and students should have the right to opt out of using ed tech products as part of their education. And as it pertains to the certification of EdTech products for use in schools in the state, determine what criteria to use when evaluating these products for certification. Determine which state entities will be charged with the certification process and extent. And recommend whether any third party services should be utilized to assist in certification. The working group will have the assistance of Cameron Wood and will be staffing working group, maybe Jonathan Gray. So
It's Friday afternoon.
I'm trying to match their level here.
We are
Doing a great
punching.
Yeah.
Doing a great job.
Left Council JFO would be involved in the working group's job. The report would not be reported in proposed legislation, so on or December 30th, the working group would submit its findings through proposed legislation to House Commerce and Senate Economic Development and Education, also House Education. Meetings will begin on or before August
Okay, we
15th.
can,
Okay,
we can
All right.
fit through this.
that's
All right.
the effective date is July 1, 2026.
Okay, well, obviously from our emails, there's some concern with this in the educational community. Should I say we will have the Bs in next week, school board, superintendents, principals? At least maybe the NEA and,
Expecting an amendment that would show that each legislative member of the group shall have no prior experience or competence in the area of education.
Absolutely. Just to drive that point home. I think it's belts and suspenders.
My concern will still be how much of what we're kind of contemplate changing is germane to finance.
Yeah.
I'm not
there was
Is
a
that either?
B in there, but
to my point.
we can do whatever we want. We can put a fee in for being on the committee.
You don't pay it.
You have to pay a fee to be appointed. Okay. I think though we should take another look. I'm not comfortable if there's that much. I at least need to hear what the concern was. We heard the concern with the charge of the bottle bill. I think we at least need to hear the concern. Things move quickly at this time of year and sometimes we miss something bigger than it's on us, so.
Well, we should hear the concerns on both sides now.
And I don't know, what is a student privacy group advocates?
There are apparently some groups that have been suggested that could work to help certify these students. I couldn't name them for you, but that's the idea.
Okay. Do they know anything about it? Okay, we will hear from the bees. We will at least hear what their concerns are. We will hear from economic, no, from education and hear what they're trying to do.
And from us too.
Well, then we will decide what we want to do. All right.
Then I go to Vanguard. Instead of, if we're gonna hear from education. Or do you mean the committee or from the,
Orders.
from the field?
We will hear
Okay.
from principals of the V's. And we will hear from the education committee, either the reporter or the chair, whoever. I guess if it's Senator Hinsdale, we'll hear from her. And then we will take a look.
Oh,
Okay.
there's every thing. This is joint feedback from the bees on our website about this.
I know I haven't gotten to my emails yet today, but I know I've had several on this.
I mean,
Principals.
I'm not a bee, but I was on a school board for a long time and I can tell you that making this worse would be an administrative nightmare.
Yeah.
And unless we're going to fund positions in schools, I'm not comfortable.
And we're trying to ask our schools to do some major work right now, and we want them to be distracted by this.
And do less with more.
We
More with
will
less, sorry.
hear from everybody. We're going to go on to another, hopefully less exciting bill, but I'm not sure. This is 7:57. Thank you. Rick.
The agency.
Oh, is that right?
Landon,
You wanna stay in this? Stay in here?
Yeah.
Okay, I don't have you on my agenda. I'm sorry. Wanna- Okay. Want to get out of here. Midnight.
And I don't know if they
We do
consider.
want to get out of here.
Okay, I need
Maybe.
law and order here. Let's go.
So, in my enthusiasm, I closed out the Zoom link, so I'm gonna jump back in. If you want me to,
Enthusiastic?
well, Rick was leaving, I thought,
Oh, you thought you were gonna get off
no, I'm always confused to be.
that. You're always confused when like
There are
leaves the room.
classes and committee management, subject staff. Committee expectations on Fridays.
All right, so we'll go ahead and just share this here.
Okay.
All right, so as you heard from Rick, this bill would do a few things. Primarily, it would require educational technology product providers to register with the Office of the Secretary of State and provide some additional information about themselves and schools or districts that they do business with. And that's the primary fiscal impact about today. Communicating
There's a
with the secretary.
reason it's here.
Well, I think the reason is here is like, well, that's up to the Secretary Bloomer, but as Rick said, at one point there was
The fee.
a fee. This is just an additional fiscal piece here. So speaking with the
That's a-
Secretary of State's office, I'm estimating between 70 and 90,000 in fiscal impact for 2020, fiscal year 2027. The bulk of that would come from the cost to the Secretary of State's office to update their IT systems. They've communicated to me that that could be anywhere from 60 to 80,000 to update their systems to absorb this additional information from votes registered.
Okay, so at this point, it's a wash. For what we're maybe, if we're lucky, cover.
So as right now, there is no fee yes right now. So this would just fall to the Secretary of State's office, their budget.
Question, thank you, Madam Chair. So Ezra, this will not cover the cost of putting new positions in all of our school districts to cover the administrative burden of the program. Is that correct?
Yeah, this is only the Secretary of State's IT cost.
Got it.
If there was additional burden on school districts, we can't estimate if they would hire new people or if they would. Yeah, that's, but that's,
Yeah, there are some schools.
Some, yeah.
there's also an additional 10,000 in per diems and expense reimbursements that we're estimating for the legislative working group that I hear Senator Mathis should be part of, so.
Only if it's the fee for.
So,
Yes, we can.
so these are the
This.
So that's really the high level. I mean, I think Rick walked you through it. Happy to.
All right, that is it for fiscal reporting. All right,
Yeah, those are the two pieces we're seeing, the IT cost and the per diems. Any other costs that could happen at the school or district level, we can't estimate that at this
Okay.
point because it would be up to every school or district
but if
to.
they've signed contracts with these various entities and they can't use the product, I'm assuming that's lost money.
I can't speak to
Yeah, I
that.
know, we don't know. I'm hoping we will hear that from the schools when we get them in. Okay, but that's it. The fees are gone. And there is the registration that would provide maybe enough revenue to update your computer system to get the increased revenue. All right.
So that would be a question for the Secretary of State's office.
Okay, all right. Thank you. We are going to go on to another new bill, an act relating to manufactured homes and limited equity cooperatives. Cameron, you're the lead on this one.
Yes, ma'am.
Is a limited equity cooperative a condo association or something similar?
No, ma'am, it is not.
Okay. Leave that one.
So, yeah, for the record, Cameron Wood, Office of Legislative Counsel. I'll share my screen and we'll start walking through 757. I'm going to walk through the as passed by House version, and then there are a few changes that are recommended by the Economic Development, Housing and General Affairs Committee that I'll kind of comment through as we go through. First, the section 1 is going to deal with some really more technical changes to the sections regarding the sale of manufactured homes. And first, before I jump in, we're talking about manufactured homes, also known as mobile homes. They were kind of referred to as mobile homes all the way up until the mid-70s when the federal government came in and put in regulations governing the manufacture of these homes. And in the federal regulations, they're referred to as manufactured housing. There is a specific definition in Title 10 that kind of matches that and talks about the dimensions that it has to meet in order to be titled a mobile home. But you might hear me just kind of using that term interchangeably.
But it
mobile
does not
manufactured.
mean the prefab homes that are put together in a factory that have wood frames. These generally have metal walls or.
I wouldn't say they have metal walls, but they're built on a
Well,
chassis.
Yeah,
They're built on a chassis and they are moved into place. And then typically when they're sited, they, especially nowadays, they don't move from there.
They have to be
But historically, and even today, purchasing a, what the federal government would call a manufactured home, it's built on a chassis and it could be moved, subsequently. I was corrected, I think, in House Ways and Means where I was told, well, there are stick-built homes that can be moved as well. And they are sometimes. And I said, touche, that's true. But ultimately, these homes are or can be mobile.
Words one time.
Correct. And so I'll use that term somewhat interchangeably. You'll see a section towards the end where it gives our office the statutory revision authority to go in and change where it's referred to as a mobile home, to change it to a manufactured home in statute. Again, to match the federal definition or the federal use of how the federal government,
and they
titles
change it.
these homes.
Okay.
Yeah. But what we didn't want to do is we didn't want to, as part of this bill, to go in for every instance to change it, because your bill would get very, very lengthy if we were making these, statutory revision changes throughout. And so the bill still refers to them as mobile. It gives us the authority to change it to manufactured homes moving forward. Okay. So again, the first few sections here are about, in Title IX, there's a chapter which governs the sale of these homes. When they're sold by a manufacturer, when they're sold by an individual, what you have to do if you're selling it to someone else, you have to go to the clerk, you have to get sign off that you paid your taxes. The information has to go to the clerk where the home is going to be moved to, if it's going to be moved, etc. So the first change is here in page 2 with the definition of permanently sited. This is important because if you're selling the home to someone else and the person who is purchasing the home is locating the home on a land that that person owns, so it's not going into a mobile home park, it's going into their property. If it is permanently sited, then it has to be financed via a mortgage as residential real estate.
Yeah.
And so the House General Committee wanted to be explicit that not all of these conditions have to be met in order for it to be deemed permanently sited. So it's been set up on blocks, you remove the wheels, connected to utilities, skirting has been installed, the wheels or axles have been removed, etc. Not all of those conditions have to be met. I would argue that by using the word include, that is already our, use of the statute. As you know, we don't include the but, but not limited to, use the word include, etc. But this is just a little cleanup from the House General Committee. The next section is about, as I mentioned, when you're talking about the sale of the home and when does it have to be conveyed via deed versus a bill of sale. And so the best way to look at this is if the individual who is purchasing the home is financing it via a residential real estate mortgage, then you must transfer the mobile home via a deed. There are, depending on where the home is going to go, it's not always financed as a mortgage. Residential real estate could be financed via a personal property loan. But if it's going to be financed via a real estate loan, it has to be transferred via a deed. And so this section outlines how that is transferred. So again, subsection A here, if you're purchasing it from a dealer after 2008, it's being financed as residential real estate, has to be conveyed via a warranty deed. And then subsection B talks about if it's financed or refinanced as real estate, then it has to be transferred via a deed. And then you get to subsection C, which is about warranty deeds. You get to subsection, pardon the scroll, you get to subsection D about quitclaim deeds. So as you can see, we're just adding in some language to clarify what section governs what. So we just added a warranty deed for subsection C, added quitclaim deed in the subsection below. The other change here that you should note is the strike through in that sentence. Currently, the statute requires that the individual receive permission from the property owner in order to sell or exclude on the deed, and that is being removed. There can be an argument as to why you want to include the owner of the property where the home is on signing off on the sale. If it's in a mobile home park, for example, the owner, the individuals may owe mobile block rent to the owner of the park. I also come to the other committees. You as the landowner may want to be aware when somebody is coming in to move the homes off of your property, given the effort that it takes to do so, etc. But the committee felt that that was unnecessary, and so they wanted to strike it. All this language here, starting on line 17 and moving forward, this is just the standard form that the statute outlines. It's not required to be used, but it's a standard form that can be used when you transfer via a deed. So again, really more just kind of technical changes, changing wife and husband to spouse on the model form. Not a lot of substantive changes there. More, I would say, is drafting cleanup for clarity. Then we get to section 2, where we start talking about limited equity cooperatives. And Madam Chair, I'll start by kind of addressing your question. There is in Title 11, which governs corporate structures, there is a chapter 14, which governs cooperative housing corporations. So these are corporations that are set up by individuals to have more of a collective home ownership model. So the corporation owns whatever the housing is, whether it's an apartment, could be an apartment building. In some instances, it's a mobile home park, where the corporation owns the park and the houses that are in the park. And then you, as an individual member of the corporation, you have a proprietary lease as part of your membership share, and that grants you the right to live in one of the units in the cooperative. A limited equity cooperative starts here on page 7. The difference between just a cooperative housing corporation, which could be for-profit corporation, versus and I just mean by for-profit corporation, I just mean it is, making money on behalf of the members who are, shareholders of that corporate structure. The limited equity cooperative, the subsection A here really outlines its purpose. So the Cooperative Housing Corporation may organize as a limited equity cooperative in order to fulfill the public purpose of providing and preserving housing for persons of households of low and moderate income at the time they purchase their membership share. So it's a cooperative housing corporation that's designed for low and moderate income people. And low and moderate income is defined as 80 and 100% of AMI. And so the way it works is the articles of incorporation of the limited equity cooperative have to have a formula that's built in to ensure that the cost to the individual member when they purchase that share is a cost that is, available to individuals of low and moderate income. The other key piece to know about a limited equity cooperative is this subdivision 6, which is when or if the limited equity cooperative ever dissolves. So it can only dissolve if the members who are, the owners elect to dissolve the corporation. If they dissolve the Cooperative Housing Corporation, any assets remaining, so starting on line 11, any assets remaining after retirement of their corporate debts and distribution to members of their share, paying them back their share costs, any assets that remain after that have to go to a designated 501c3 entity or to another limited equity cooperative whose formula is no less restrictive than the one that the cooperation dissolved. So you're limiting what you can do with the assets of this corporation if it ever were to cease to exist. Okay. I'm gonna pause there. Any questions before I jump into the actual changes we're talking about here?
Okay.
Yeah, because that's all current law.
Yes, ma'am.
Yeah.
Okay. So the changes that you have I'm gonna start here on this subdivision 7. Current law. Articles of incorporation require that in a limited equity cooperative, you cannot sublease a unit for more than 110% of your proprietary lease costs. Okay. Think about it this way. You live in an apartment building. There's 5 units in the apartment. You're all in a limited equity cooperative and you're paying $800 a month for your proprietary lease, which gives you the right to live in one of the units. And that's your proprietary lease cost that goes to the limited equity cooperative. It gets pooled, and that's the money that they use to cover whatever the expenses are for the corporation. Exactly. Yes, ma'am. So the concern that was being raised in the House General Committee is that for some of these limited equity cooperatives that are mobile home parks, the proprietary lease may only give you the ability to put your own mobile home in the park. So in this scenario, the corporation doesn't own the mobile home. The person owns the mobile home. But their proprietary lease as a member of the corporation gives them a right to put their mobile home in the lot.
Hook up to water.
Yes, ma'am. Yep. And so their mobile home lot, their proprietary lease only requires them to pay for the mobile home lot costs, which could in some cases be relatively low. It might only be a few $100s. And so then if you need to sublease out your home for whatever reason, you're limited to only being able to charge 110% of your proprietary lease. So if your mobile home lot rent is $100, you can only sublease the entire house out for $110. And there was concern about that because in some of these parks, as I mentioned, the person owns the mobile home, they may have a mortgage on it. Madam Chair, as you mentioned. So that's why you have the changes on page 8, which says that notwithstanding that section, for a mobile home park organized as a limited equity cooperative, the articles of incorporation shall prohibit the subleasing of the unit unless The member demonstrates a hardship, in which case the board of directors may grant an exemption from the prohibition. You may say right off, well, why are we going to limit it entirely? I can't answer that question. I can say, because that's a policy question for that committee, but I can say it is somewhat in line with the language around cooperative housing corporations. Because you have a corporation and it's designed for members to live there. It's designed as a collective ownership, home ownership model. And so in the statute chapter, in the chapter governing the cooperative housing corporations, there are sections that limit the ability to sublease to only 1 year at a time. And then it says that 80% of the units within the corporate housing structure need to be leased by members. Yeah. So there are other statutory pieces that limit what can be subleased, how many units can be subleased at a time, etc. So this says for a mobile home park with limited equity cooperative, no subleasing unless you demonstrate a hardship. And the unit has to be subleased to an individual of low or moderate income. Again, that's what the limited equity cooperative is designed for those individuals. Okay. Then the articles of incorporation, if you're going to sublease it, it says that they have to require that the unit owner shall not sublease the unit for a higher amount than necessary to cover the costs, which include the proprietary lease, mortgage, utilities that are passed on to the subleasing. That's the first change. Capping how a mobile home park limited equity cooperative can sublease their.
So you can't make it up.
Yes, ma'am, but you can cover your costs.
Right.
Okay. Then we get to B. B1. There was a lot of discussion throughout this bill moving through different committees about the registration of these entities with the Secretary of State's office. This is a corporation. It has to register with the Secretary of State. At one point in time, the Secretary of State's office was listing these limited equity cooperatives as nonprofit corporations within their registration system. And then at a point in time, they stopped doing that. Why did they stop doing that? Because technically they're not nonprofit corporations. They're just not. It's an entirely different organization structure. And so apparently that distinction, the fact that some of them are listed publicly as nonprofit entities and some of them are not being listed that way, creates problems for the ones that are not listed as a nonprofit entity. Because when they go to access state funding and grant opportunities, if they're not listed as a nonprofit, they have to jump through additional barriers to demonstrate their eligibility for those funds. Whereas apparently the ones that are simply, hey, Secretary of State has us listed as a nonprofit, they can kind of breeze through and no problem.
This might be things like water and sewer. Those seem to be the big issues.
Yes, ma'am. Exactly.
Okay.
So there was discussion in committee about, well, why don't we just change all of them to say they're all nonprofit entities? And you really can't do that because, and the Secretary of State's office made it very clear at the end, after this was in Senate Economic Development, that they're not nonprofit entities. There's nothing about them that is organized as a nonprofit entity. Separate from that, you have to keep in mind there are two things here. Nonprofit is just an organization structure at the Secretary of State. That has nothing to do with whether you're tax exempt at the federal level. So tax exemption at the federal level is different from being registered as a nonprofit with the state. And so it's not really appropriate to just wave a statutory wand and say all of these things should be listed as nonprofits because legally they're not. So what the House General Committee landed on was this B1, which is to say that a mobile home park organized as a limited equity cooperative shall be treated for purposes of state funding and grants as if it were incorporated as a state nonprofit corporation for a public purpose and public benefit. Now, there's a little bit of, validity to that, because when you go up to the top, if you remember, I mentioned that for a limited equity cooperative in statute, it says that it is designed to fulfill this public purpose of providing and preserving housing for persons of low and moderate income. So it is serving a public purpose. There are some concerns, I think, with having a very blanket statement like this of just saying for all state funding and grants, you should be treated like a nonprofit. Again, for starters, nonprofit status is just an organization type. That's all it is. And it has nothing to do with whether you receive tax exempt status at the federal level. And so that concern was raised by the Secretary of State's office during the process of whether it's really appropriate to phrase it this way or to do this. A few other quick things. Nothing in the section is deemed to alter or change specific funding or grant requirements. So the concern there was, you know, if you have a funding stream that isn't available to mobile home parks because it's available to something else, you know, we're not trying to change the criteria for specific funding streams here. And then Ways and Means added in this language at the top of page 9, nothing shall be interpreted to impact or alter the tax treatment of these entities. So what does this do? It gives some level of statutory language for these entities that are not registered and listed as a nonprofit. It gives them some statutory language they can point to when they go to apply for certain state funding and grant opportunities to say, hey, the state really does think that we serve a public purpose similar to what a nonprofit organization does. We talked a little bit in the Senate Economic Development Committee about whether or not it's more appropriate to just go amend whatever these state funding and grant streams are to ensure that they're available to these entities. And that's where you get the amendment from Senate Economic Development, Housing and General Affairs. Their amendment is going to put a sunset on that section. 1 year sunset. So it will be repealed July of next year. And then it requires the Department of Housing and Community Development, in consultation with other entities, Agency of Administration, A&R, AOT, to submit a written report identifying, starting on line 11 here, identifying all state funding and grant and loan programs available to mobile home parks for infrastructure improvement with an analysis on the eligibility and regulatory barriers prohibiting access to the funds for mobile home parks registered as limited equity cooperatives. Trying to give you as much information as possible to try to address the direct question that led to the language being proposed in the first place. Why DHCD? They oversee, they have a specific division in DHCD, their mobile home division. So, you know, in conversation with the committee, it felt like they were probably best to answer this question. So, sunset, 1 year, report back. And the last thing I will mention, and then open it up to questions before I turn it over to my colleague John to talk about the rest of the bill. There's a section in here regarding municipal zoning, which would add in for this list of housing. So no bylaw of a municipality shall have the effect of excluding mobile homes, modular housing, or prefabricated housing. That is current law. And this would add in to say that you cannot have a bylaw that prohibits that type of housing in any district that allows year-round residential development.
We were just discussing this language. It's Senate Natural Resources.
It's in another bill, yes, ma'am.
It's not quite, this is a little bit different.
And there were some other things in that bill that are not
Yeah.
here. Yes, ma'am.
Yeah, right. That's
Yes, ma'am.
a question. What's the definition of district in that phrase?
Good question. I'm probably not the best person to answer that. This is technically in Ellen's area because it deals with, land use policy.
Usually towns are broken up into zoning districts.
So in Burlington, would it be like a ward? We have wards.
No, it's about land use and zoning and what can be built. And
You can't say you cannot put.
So it's not a political.
In a residential neighborhood.
Got it.
Does that mean you can't, if you allow residential stick-built development, you cannot ban a mobile home park,
Manufactured.
manufactured home?
But
I
you-
thought that
you-
was already.
You wouldn't be able to ban the mobile home.
Right.
Yeah, this one
It
doesn't.
it wouldn't
include
have anything to do with the
manufacturing.
park,
Bill does.
Right.
Yeah.
It might not be an allowable use in that zoning district.
but it would just be the home. If you have a single family lot, somebody
Yeah, then
could put
nobody
the
can
mobile.
put it.
home.
No,
That was already.
there, but a mobile home park may not be.
Oh, right. It takes more land than single.
Okay, so then, here's some sales and use tax exemption, which I'm gonna let John talk about in just a second. These last two sections, Secretary of State Business Registration. The committee is adding this in, if you remember. I said that there was discussion about whether or not to just unilaterally change the registration for some of these entities to list them as nonprofits. Secretary of State was not, open to that for many reasons, some of which I have discussed. So what do you do about the ones that are listed as nonprofits with the Secretary of State? And they really shouldn't be. And the Secretary of State's office was not comfortable similarly with just going in and unilaterally changing them. Because there are, legal consequences that go with that when it comes to their reporting structure, how often they have to report, etc. So what they landed on was this session law language that gives the Secretary of State the authority to update a limited equity cooperatives registration to ensure proper reflection of the corporate business organization structure within the Secretary of State's system. I don't imagine any entity taking advantage of this because it would probably be to their detriment if they did. But it's there. And then conforming revisions, as I mentioned at the top, this gives our office the ability to replace mobile home with manufactured home throughout the statutes as necessary. To again, try to align your statutes, which refer frequently to mobile homes. There's a chapter about mobile home sales. We talked about at the beginning. There's a chapter about mobile home parks, etc. To change where it's phrased mobile homes and manufactured.
So I'm reporting the underlying bill from the morning committee and selfishly I want to ask this question that is germane to what we just heard. When did the Secretary of State stop classifying these as nonprofits? And do you have any other additional background on why? I heard you because they didn't think it was that, but was it the new Secretary of State? Was it some other law that triggered the reconsideration?
To my knowledge, no, sir.
Okay.
As you all, probably are aware, they've been working on a new IT systems with the Secretary of State's office for a few years now. My assumption is, when you've been at labor, when you start going through that process, you're looking at all of your, business rules and your process that you're doing, whether they need to be updated, et cetera. So my assumption is during that, I will ask because I don't have a direct answer to that. I don't believe it was any, the new Secretary of State came in and said, hey, stop doing this. I don't think it was.
And with the prospective repeal for the 1 year where they would be eligible for these types of grants, do you anticipate any concerns with grants then being rescinded if that status changes? Is that too broad of a question to really speak to?
I don't think so. Because technically the entity that's issuing the funds really should be ensuring that with this language or not, the entity that's receiving the money is eligible based on the criteria of whatever that state funding or grant statutory criteria is. And so I think if you repeal this language that we looked at above, where you have the sunset, you're not repealing the underlying authority to issue those funds to begin with. So I don't think you would run into any issue with that concern.
I could keep asking more questions to keep us here later on Friday.
Thank you.
I was gonna ask what, but.
Okay, we still have John and Jen.
Thanks, Cameron.
You're welcome.
Never to go.
Yeah.
You're welcome.
If we're moving this out.
I'm not being any red flags, but I'll look to maybe it's the.
John may have some.
I was wondering what
red
that-
flag.
You asked.
No red flags.
Okay.
What you want questions? I might ask two of the members of the committee. In the morning.
We don't understand the way that.
Well, that's. It's your second time hearing it, Senator.
There are some movable parts that aren't able to access some resources and because of recognition change. And so this is just trying to correct that in a fair way and do some other things that John's going to tell us about.
Hello.
Hello.
John.
Welcome to Friday.
Happy Friday.
Yes.
I'm John Gray, the Select Center Council. I have two short, quick sections to share with you that don't say much, but do have a meaningful effect. And I think before walking through the language, this is an update to the sales and use tax exemption for mobile homes. The first thing to do is to call back to something that Cameron spoke about in the beginning. You'll recall him talking about transferring by deed or by bill of sale. Part of that conversation is whether or not a mobile home is treated as real property or tangible personal property. You might have questions about that. I don't especially want to answer them. But
Real property owns property taxes.
Yep, there you go. I think that's a simple way to put it, because they're movable in the first place. One could ask the question, what does it mean for a mobile home to be real? We typically mean affixed to property, right? But anyway, the point is that property law treatment produces the tax law treatment. And so what that means is that for your one-time taxes that hit mobile homes, real mobile homes that are treated as real property are subject to the property transfer tax, and mobile homes that are treated as tangible personal property are subjected to the sales and use tax. Under current law, those rates are quite different, and I can pull them up if it's helpful. The property transfer tax, you can see here 1.25%, but you also want to note this subdivision 1, which is particularly relevant here. With respect to the transfer of property to be used as the principal residence, the tax shall be imposed at the rate of 0.5% on the first 200K. So what this means is a mobile home treated as real property is subjected to this tax, and that effective tax rate is going to be somewhere between, I think, 0.5 and the 1.25, depending on the value that it has. And there may be some other complications there, but that's the kind of rate that's the range of rates that you're looking at if you're talking about treated as real property. Sales and use tax is different, right? The tax to be paid at the rate of 6% of the sales price. So what you're seeing is the problem that animated the language you see here is an attempt to say, well, in both cases, they're being sold to be homes essentially, so they should receive the same kind of tax treatment. Initially, this began as a concept that would have tried to subject all mobile homes to the PTT, and basically resulted in them always being treated as real property were that possible. It resulted in some pretty odd things, like subjecting tangible personal property to concepts that only apply to real property. So a sort of more intuitive approach was reached, which instead of disrupting the connection between property law treatment and tax law treatment, just leave those as is. You get the sales and use tax, you get the property transfer tax. Just try to create a comparable effective tax rate for the mobile homes. So currently, the mobile homes under the sales and use tax are hit by that higher rate, right? And so these are the changes I'm going to show you are trying to create parity across the PTT and the sales and use tax. You're only going to see sales and use tax here because they're more advantaged on the property transfer tax. So you're bringing those homes in line with what's done for real property. Does that make sense? Mm-hmm. There's a piece I didn't mention, but now that we have the language, I can talk about it. So one is that, and you see here under sub S, there is already an existing exemption for mobile homes and modular housing under the sales and use tax, but it's of a particular percentage. It wouldn't create that effective tax rate that you're looking for. And what you can see in the struck through language is that the existing exemption is to provide an exemption for the estimated portion of the cost attributable to labor. So it was not something that was solely intended to create parity across the two, just both because they happen to be homes. You see that struck through now because the change that's being made is just to have them treated essentially the same. The other piece I wanted to note is, as you can imagine, if you're trying to create parity, you need to make sure that you pick up any existing exemptions under the PTT and apply them to the sales and use tax. So you may recall from either last year or the year before, there was a wholesale property transfer tax exemption provided to these energy efficient mobile homes. And so to ensure that they receive the same treatment
if they happen to be tangible personal property, that same exemption was extended to the sales and use tax. Those are just the statutory purposes. The actual language is in section 6 here. Retail sales and use shall be exempt from the tax on retail sales. And the use tax imposed under section 973. And these are the changes. So there's already an existing exemption for mobile homes, modular housing. That was at 40%, was based on that portion attributable construction cost. It's bumped up to 90%. And if you think about what this does, if you have a 6% sales and use tax, and you're now multiplying it by 10% because 90% is exempt, it's basically producing a tax rate of 0.6%. So in that range of the near the 0.5, the 1.25 that you saw under the property transfer tax. I'm sure Ted will have more to say about this, or he can contradict me. I hope not. So that is the first change. Again, the simple way to think about it is you're just trying to create the same effective tax rate for a manufactured home, whether it's just treated as real personal property or tangible personal property. That's the whole idea of it. And then this one's pretty simple. You already saw the statutory purpose for this. This is using the language that's already used in the property transfer tax exemption. That's a wholesale exemption from property transfer tax for new mobile homes. I can pull up that definition if you're interested, but I hope not. That bears a label evidencing greater energy efficiency or are certified as zero energy ready home by the Department of Energy. This is not new. I did no digging on how this works. I just pulled it in from the property transfer tax to create equal treatment across both taxes. That's it. That's my whole spiel. And I'm sorry, I should say that it doesn't go effective until January 1 of next year. So it wouldn't kick in this summer, get the tax department done.
All right, questions for John? You basically haven't changed the purchase and use tax. You just changed what it is applied to.
So the way I think the simplest way to think about it is that mobile homes, at least from this one-time tax standpoint, are more advantaged if they're subjected to the property transfer tax. So when you're thinking about how to create parity, you could move in either direction, right? You could treat real property worse, or you could treat personal property better. This bill opts to treat personal property better. It opts to bring them in line with the way that real property is treated. Does nothing to the property transfer tax. It just extends the same thinking, the same economic thinking to the sales and use tax. The property transfer tax remains exactly as is. It just amends the sales and use tax to extend the exemptions to mobile homes in the same way that they're essentially received.
Well, I got the Energy Star exemption. It's okay.
And the change from 40 to 90% exemptions
Yes.
for the mobile homes is to create that same effective, a comparable effective tax rate.
Okay, because it is the land frequently that adds the value to the mobile home. If you own the land, it's a lot easier to get a mortgage.
Yep. And I think that's a lot of the complexity that went into this. All the stages of this bill really was that many buyers are approaching from the same perspective. This is going to be a home, but there's some factual difference that puts them in a different bucket in terms of taxation and what they can finance that may not be a meaningful indication about them. It's more of an indication about the way we have set up the law. So this is an attempt to, I think, conform more if possible. It doesn't always look that way, but that is my simple description of what the bill is trying to do.
Okay, Ted, do you want to
Sure.
tell us what all of this is going to cost
Absolutely.
or make? But I have
No.
a feeling it's not going to make us.
Yeah,
any
yeah.
Government Joint Fiscal Office. I'm going to start in a similar place and not at all contradict John, who did a great introduction to this topic and how he ended up with the 90%.
That's sarcastic.
Cam did a great job as well. So looking at the data for property transfer tax and how this is kind of leading into how the 90% exemption was arrived at. Under the property transfer tax, most manufactured home transactions are principal residences, and the value of those transfers is less than $200,000. So the vast majority of properties are paying a tax rate of 0.5%. There are a few that go above that marginal value and pay the marginal value of 200,000 and pay 1.25%. There are amazingly some that are transferred as secondary residences and even some that are paying the 3.4%, which I thought was fascinating. What that works out to being is that when you take the total tax paid and factor it into the number of transactions, the effective tax rate overall was 0.6%, not including the clean water surcharge, which the mobile home transactions or manufactured home transactions would pay if they were secondary residences or on the marginal value above 200,000 for a principal residence. So yes, so you have an effective rate of 0.6%. And so as John walked you through, to convert, to create parity between the actual data that was seen on the property transfer tax and the 6% sales and use tax rate, you just leave 10% subject to tax, and then you get the same 0.6% rate. What that means, and the data, so the fiscal impact, because it's a half year in fiscal year 27, there's an effective date of January 1st. That means that it would reduce sales tax revenues to the education fund by $200,000. You're increasing the exemption from 40 to 90%, and that's in fiscal year 27. And then the cost of the exemption would increase to approximately $500,000 in fiscal years after fiscal year 27. And so standard disclaimer applies absent any adjustments to policy. The homestead property yield or statewide non-homestead property tax rate may need to be adjusted to account for this foregone revenue. That is the main. Oh yes, and so these data, the data from for the sales tax exemption comes from the tax expenditure report. Since it is an existing sales tax expenditure, it's just increasing it. We base the estimate from this data and also used actual property transfer tax data. Yes, and that's the main fiscal impact of the bill that's covered in the fiscal note. Would also note that the 1-year provision by which all limited equity cooperatives are treated as nonprofit for grant purposes, it doesn't necessarily change the pool of resources, but it could add a few additional applicants to the pools for state grants and resources for that 1 year when it's in effect. But I think you'll have much more data in the report that's coming about the types of state grant opportunities that are available to housing and manufactured home cooperatives. And yeah, we'll spend more time thinking about it eventually in the context of that report.
Okay. Committee, I think I would like to give us until Tuesday to let this percolate.
Yeah.
A lot of numbers and a lot of concepts.
Can I ask this a big issue? Because I'm really tired and I don't think I followed. Sorry, Jonathan. I'm not sure I followed. I was following Cameron, but then I got completely lost. Sorry, John. But my question is.
I was so clear.
It's my brain, not you. I'm just really tired. It's Friday. It's been a long week. But is it just coincidental that the numbers that it work out?
There was a data ask for me to say, if you wanted to create, because there's early testimony about the effective tax rate paid for real property transfer actions under the property transfer tax. And the question was, what would the sales tax exemption have to increase to make those line up? And essentially what people are paying in the sales tax lines up with that 0.6% effective tax rate.
So if the rates change, won't we have to do some kind of adjustment in the future?
For the property transfer tax?
Make it equivalent again?
Yes, if you did adjust the property transfer tax rates, you'd have to adjust it. If you did any work on those.
So you backed into it. It wasn't just coincidental that it was neat.
Exactly, yes.
Okay.
Yep.
About,
You're asking if it's a whole number by accident or?
yeah,
Yeah, and 90, I mean, it's not, I think, probably the effective tax rate is a much longer percentage than 0.06.
yeah,
And so the 90% was done to be close enough. right?
okay. But if any element in there and you're carefully calculated scenario changes, then we would have to change other numbers too in the future.
There could be a situation where you're picking, the property transfer tax, even the threshold values for when you pay different rates.
Yeah,
As inflation increases, the effective tax rate would go up and you could consider decreasing the sales tax exemption
Yeah.
and make them match.
it's not gonna happen automatically.
No,
Or manufactured homes start to cost more?
yeah,
Right.
exactly.
So it's something we're gonna have to come back to and tweak if we want to keep the same ratios to taxes.
Yes, and if you wanted them to match like really closely match up, it
Okay,
depends on the tolerance, right? And how far
Okay.
they can deviate.
I still don't quite understand it, but I did understand that there was this relationship that seemed like it was, no pun intended, a manufactured relationship, and that if we want to continue that relationship into the future, we might have to take continued action. Okay.
Okay.